I'm just going to announce it again. Anybody's car keys, GMC, United States Naval Academy. If not, at the end of the day, I'll give them to the folks at the registration desk. So, but if you're missing those, also want to let you know that all of the materials from today's presentations, like Randy's presentation and Dana's presentation, didn't make it into the publication book. They will be available online on the State Bar website. Probably take a couple weeks to get those uploaded. And then if you've noticed in the back, it's being recorded. The entire CLE in its entirety will be on the State Bar website where you can click it and watch it. So if you've got some colleagues or coworkers that were over in the ethics CLE or couldn't make it here today, it will be available online at the State Bar website. So with that, I'm going to introduce our last speaker of today. Dana Hanna is going to talk to us about ICWA and the lawsuit that's up on the screen there. Dana was in private practice in New York as a criminal defense attorney, returned to South Dakota where he worked for the Rosebud Sioux Tribe for 10 years. He was the criminal public defender and the Attorney General for the Rosebud Sioux Tribe during that time. And since 2007, he's been in private practice here in Rapid City with his focus in Indian law and representing folks in state and federal court. So, Mr. Hanna, thank you for being here.
Hey.
Thank you, Megan. Thank you. I'm going to start by giving a very, very brief summary of the Indian Child Welfare Act, on the off chance that some of you may not be entirely familiar with it, but the topic is not going to be about what ICWA says. It's going to be about what a federal court says ICWA says. In this particular federal civil rights case, Ogallala Sioux Tribe versus Van Hunnick, which is pending right now in the federal court here in Rapid City, and which recently resulted in the federal court granting summary judgment for the Indian plaintiffs in 7 of the 7 claims we raised. The Indian Child Welfare Act was passed in 1978, I believe, and basically they passed it, Congress passed it, after making a great deal of study and coming to the conclusion, based on objective study, that institutionalized racism in state courts was the rule rather than the exception in abuse and neglect cases involving Indian children. Something like one-third of all Indian children at that point had been removed from their families temporarily or permanently in abuse and neglect cases. And state courts, state prosecutors, and state social workers, who were overwhelmingly white, with amazing regularity determined and predictability determined that it was better in the best interest of Indian children not to be raised by Indian parents or in Indian families or in Indian communities. Congress determined that that is not in the best interest of Indian children. There's plenty of evidence to back that up. And so they passed the Indian Child Welfare Act, which created minimal federal standards that have to be applied in state court whenever a state court or state government seeks to remove an Indian child from his or her family, temporarily or permanently. One of the very important parts of the Indian Child Welfare Act is that it gave tribes party status in these cases. That is, Congress found that this was such a danger to the integrity of the tribes that the degree to which Indian children were being removed from their families for long periods of time, including permanently, actually posed a threat in the long run to the existence of tribes themselves. So they said, tribes have a stake in this. They have a right to be a party in the case. They can intervene whenever there is a state court proceeding that involves the state seeking to take custody of an Indian child. Cut to 2011. Cheyenne River Sioux Tribe and Pine and Ogallala Sioux Tribe that make a determination. We don't want to get into these cases after the kids have been in foster care for 90 days. We want to get into these cases at the first day, at the first opportunity. And therefore they hired counsel to represent them, counsel being me. And they directed me to get into these cases at the very first hearing, which we call in South Dakota a 48-hour temporary custody hearing. An emergency here's how it goes. Emergency occurs, or what the police determine to be as an emergency. For whatever reason, they believe these children are not safe at home, or maybe both parents have been arrested, maybe something bad has happened, the parents have abandoned the kids, whatever. But for whatever reason, police make a decision, we're taking custody of those children. State law applies. ICWA does not apply in that situation. Then, under state statute, which is basically a codification of a constitutional requirement, there has to be a 48-hour temporary custody hearing to determine whether those children should be returned to their parents or stay in state custody. These hearings are initiated by the state filing a petition for temporary custody, saying, we've taken emergency custody of these children, we want to keep custody of these children for at least the next 60 days. Now in 2011, it was routine that the request was always for 60 days. And once I was retained to represent the tribes in these initial hearings, I was very surprised to learn that these hearings typically lasted 2 minutes. No parents were ever advised that they had any rights. No evidence was presented. And in what was basically a rubber stamping ritual, the court always gave custody to the state, granted their petition, and then granted them custody of the kids for 60 days, adjourned the case for an advisory hearing at which they would be advised of their rights. So 60 days after their kids were taken into foster care and state custody, they were told that they have some rights. And after that, the process was 30 days after the advisory hearing, if they denied the petition, because they would get the petition at the advisory hearing. Then there would be an evidentiary hearing to determine whether or not the kids were abused or neglected. So the system was, the very first time parents had an opportunity, and this wasn't just Indian parents, this is everybody. The very first time they would have an opportunity to hear the state present any evidence as to why their kids are in foster care was after the kids have been in foster care for 90 days. So, Oglala Sioux Tribe, Cheyenne River Sioux Tribe, Rosebud Sioux Tribe, who's also involved in this, thought, we've got to do something about this. So one of the things we did is we reached out to the American Civil Liberties Union. And my friend and colleague, Stephen Pivar of the American Civil Liberties Union, American Civil Liberties Union Racial Justice Project, with whom I had worked before in South Dakota, became very interested in this. And to make a long story short, after a year or more of fruitless attempts at negotiation with state authorities, we filed a federal lawsuit. Before I go into that lawsuit, I want to tell you what we did first, though. In these hearings, typically, the parents were just not given any opportunity to be heard. No evidence was presented. And in one particular hearing, in which I was representing the Cheyenne River Sioux Tribe, the state had taken custody, DSS had taken emergency custody of some children whose cops came to their house because the girl was sick in the middle of the night. Parent wasn't there. They took custody. Should they have taken custody? Absolutely. No parents there. But the mother had a story as to why she wasn't there at her home, and it basically involved an emergency and unforeseen circumstances when she was back in Eagle Butte visiting her family. Anyway, whether or not that was true or even whether it was a valid reason, she had a reason to tell that she had a right to tell it to the court. And in the 48-hour hearing, I asked the judge, Your Honor, the mother would like to speak. She has an explanation for why she wasn't there and why the state should not take her kids. I don't want to hear it, was the judicial response. Your Honor, on behalf of the tribe wants you to know that that these kids should not go into custody. You should not grant their petition for temporary custody because she has a good reason why she was not there that night, and you should hear it. I don't want to hear it. And his reasoned legal argument for that was, this is a 48-hour hearing, counselor. So, there was absolutely no evidence presented in that hearing. None. No documents presented, nobody testified, and at the end of it, the judge made these findings of fact. Returning the child is likely to result in serious emotional harm or physical harm to the children. This is the least restrictive alternative consistent with the children's best interest, and DSS has made reasonable efforts to avoid taking these children into foster care. He made those decisions, those findings of fact, based on no evidence whatsoever. So at that point, we were thinking about a federal lawsuit, plotting and scheming and doing legal research and thinking how we were going to put this together. But I was so incensed about this. I thought, this is a no-brainer. Let's not wait to go federal. Let's file a petition for writ of mandamus in the state court because it's a no-brainer. And our issue was the tribe has been denied its rights under ICWA because the state court has taken custody of Indian children and made findings of fact based on literally no evidence whatsoever. That was the issue. That went up to the state Supreme Court, Cheyenne River Sioux Tribe versus Davis. And we got an opinion back saying, of course there was evidence. There was evidence because somebody said somewhere along the line in the brief that the department had given, or the state, had given the court an ICWA affidavit signed by a DSS worker, basically summarizing what happened, and the police report. Now this was ex parte. The parents weren't given that. And what's more, there was absolutely no mention of it, of ICWA affidavits or police reports in the transcript of the hearing. The court made no mention that he had relied on that or even read it. And yet the state Supreme Court found this is evidence. They presented evidence, and so we're denying your writ. Well, I heard a civil rights lawyer talk recently. He was involved in an issue, a campaign basically, for civil rights. And he talked about losing forward. You're not going to win every battle, but you can actually lose and benefit from it. And we really gained something from that really total loss in terms of the decision. And what we learned there is we need to go to federal court if we're going to get justice here. Now, I had Indian clients from tribal councils tell me, we have no faith in the state court system. You should go to federal court. We do have faith in the federal court system. And me, being the lawyer and all. Well, no, this is a no-brainer. We'll take this to the state Supreme Court and we'll get a victory here and we'll get started on making things right. Well, obviously they were right and I was wrong. But it was a good lesson. And it made things very, very easy for us to figure out the next step. We're not going to talk about appealing cases to the state Supreme Court at this point. We're going to bring a federal civil rights action. And we're going to get our justice there. So we used 42 United States Code, Section 1983, Federal Civil Rights Act. The history of that bill should resonate with what's happening in this case. After the Civil War, the Confederacy slave states sought to deny black citizens their federal civil rights by passing state laws and exercising state jurisdiction to thwart their federal civil rights. Congress passed 42 United States Code 1983 which means a party who has been denied federal rights, constitutional or federal statutory rights, by a state official acting under color of law can sue that state official for money damages or whatever other relief is available. So, we believed and argued that the state officials in this case were denying the Indian plaintiffs federal constitutional rights and federal statutory rights under ICWA, and we focused on the very first part of the proceedings, the emergency taking and removal, and the 48-hour hearings. And our clients were, the plaintiffs are, the Ogallala Sioux tribe and the Rosebud Sioux tribe, acting as parens patriae for all their tribal citizens. And 2 Indian women who had been mothers, who had been in the system, whose kids had been taken. One was Madonna Papan, and the other is Lisa Young. And they acted as representatives of a class consisting of all Indian parents in Pennington County. And the parens patriae is a very interesting and important part of this case. The defendants, when they made their motion to dismiss, said you can't bring an action on behalf of everybody in the tribe as parens patriae. And the court says, yes, you can. If it involves not just 2 people or 3 people, but basically the entire tribe, every time they get into these hearings, yes, they can. And that has huge ramifications beyond Indian Child Welfare Act, should this go farther and be affirmed in the 8th Circuit or elsewhere. But the defendants, we chose to sue 2 supervisors from the Department of Social Services, one of whom is Ms. Van Hunting, and the state's attorney. And Mark Vargo just recently became state's attorney when we had to sue him. And I called him up the day of the suit because these processes had been going on with his predecessor. I said, Mark, I don't want you to read this in the newspaper, but we're going to have to sue you. You've inherited this case, and we're not going to try to villainize you or anything, but I wanted you to hear it from me rather than reading it in the paper. But he's the county attorney, the state's attorney for Pennington County. And the other was presiding judge of the 7th Circuit, Judge Davis. And it was our theory that we pled in our complaint, he sets policy. He sets policy for the other judges in the 7th Circuit. And the court eventually found that he did set policy, and that the state's attorney and DSS bought into that policy by following his procedures and not challenging them. But here was the situation when eventually we filed a motion for summary judgment, which, as you know, you're saying there are no disputes of facts, so we don't need a jury trial. We're entitled to a judgment on the law. The facts were 100 or more transcripts of 48-hour hearings, and we spent the first part of the case was getting them. They fought tooth and nail to keep us from getting those transcripts. The judge ordered them to make them available to them. And based upon those transcripts, the court made findings of undisputed facts. And these are some of the undisputed facts that the court found existed when we filed our lawsuit and when he was ruling on his motion for summary judgment. 823 Indian children were involved in 48-hour custody hearings in the court in Pennington County between 2010 and 2013. In 100% of those custody hearings, the presiding judge granted the state's petition for temporary custody of the children. And in none of those hearings did any witness ever testify, nor was any exhibits, documents of any kind offered into evidence to support the state's petition to take custody of these children. Neither Judge Davis or any other Seventh Circuit judge ever advised any Indian parent they had a right to contest the state's petition for temporary custody of the children in the 48-hour hearing. Now think about that for a minute. The state brings you into a courtroom, the court is presiding over a petition, the state is asking the judge to order that your children be taken from you and placed in foster care, and nobody, not the judge, not anybody else, ever tells an Indian parent, you have a right to challenge and contest the state's petition in this hearing. That never happened one time. After we filed our lawsuit, what they are advising now is if the state files a petition for abuse and neglect, then you will have certain rights, and here are the rights you will have. They're still not told to this day. You have rights to contest this petition in this hearing. These are undisputed facts found by the court. From 2010 to 2015, none of the Seventh Circuit judges ever required the state to present sworn testimony, put on a live witness. Not a single live witness ever testified in one of these hearings. Judge Davis never advised Indian parents of their right to testify or to call witnesses at the hearing. In fact, they are told just the opposite. We are not taking any testimony in this hearing. Parents were never advised they could request a brief continuance to retain an attorney. Now, ICWA gives parents, as well as state statutes here in South Dakota, gives parents in an abuse and neglect case the right to have an attorney. But the court never advised them if they had a right to attorney until he had already ordered the children into custody, which means for all intents and purposes they're denied the right to have any representation in that actual critical 48-hour hearing. Following the 48-hour hearings in which nobody testified and no documents were offered or received, Seventh Circuit judges routinely just placed check marks next to findings of fact on a form order granting temporary custody to the state without providing any explanation on the record as to the basis of their findings. Those findings being least restrictive alternative, likelihood of harm, and active efforts to prevent taking the children. Seventh Circuit judges signed temporary custody orders detailing findings of fact, those three being most important, that had never been described on the record or explained to the Indian parents present at the hearing. In other words, they weren't based on any evidence. Now, the first thing that should come to your mind is due process. Anybody? No, the state, nor shall any state, this is the 14th Amendment, of course, nor shall any state deprive any person of life, liberty, or property without due process of law. If they want to take something from you, they've got to give you a hearing. What is due process? Two things you will recall from your first year constitutional law: notice and an opportunity to be heard. A meaningful hearing at a meaningful time, and the third requirement is a neutral fact finder. These are the three requirements for due process of law. Adequate notice means you have some rights. You have a right to contest this petition in this hearing. You have a right to counsel. You're being accused of this. This is what the standard of the legal standard is that will apply in this hearing. You have an opportunity to be heard. That means you have an opportunity to tell the judge why you should not take my children for the next 60 days, and you have a right to a neutral fact finder. Life, liberty, or property without due process of law. Custody of your children is a liberty. It is one of the most fundamental liberties we have as people in the United States of America. And that liberty interest cannot be taken from you without due process of law, a meaningful hearing at a meaningful time. Now, the Constitution allows the state to take something from you, like your kids, in an emergency situation without a court order if there's an emergency situation. But it also requires a prompt post-deprivation hearing. meaningful post-deprivation hearing. This is an Eighth Circuit case authored by our own Judge Cornman, sitting by designation, Wiseman versus Reinhardt. They sued, the parents sued what was the equivalent of DSS in Missouri, and because they hadn't given the parents a hearing after they took their kids for like 17 days, 14 days, something like that. And the Eighth Circuit ruled that's a violation of due process. You should have the state has the burden of setting up a hearing, a meaningful hearing, after they took the children, and 14 days was too long. That's our state statute that says 48 hours is a codification, basically, of this constitutional requirement. So we made, after we got the transcripts and, we made 7 claims in all. 5 due process claims, 5 claims of violation of due process, and 2 claims of